whether or not they were wrongful convictions. But it does, I mean, we all have to recognize that while we have a good criminal legal system, it is not perfect. And it merits review, and if somebody is facing the death penalty, we better be damn sure that we've got the right person and the evidence to prove it.
Commissioner Calvey, same question to you.
I also don't know the facts of those cases. I did in the Julius Jones case. I actually did suggest publicly that the case should be granted clemency for this reason, not because I think that Julius Jones is innocent of the crime, but because that process had been tainted by the current DA when right before the Pardon and Parole Board was going to make a ruling on that case on whether or not to grant clemency, the current DA filed a bogus grand jury against the Pardon and Parole Board. That was a bullying tactic. I mean, something right out of a banana republic. And I said so. I called the DA out on that and did suggest and call for that Julius Jones be granted clemency, not be released from prison, but be granted clemency, and that's what the governor did.
Storme, next question for you.
This question will begin with Ms. Behenna. The U.S. Supreme Court's decision in Dobbs v. Jackson this year necessitates our discussion of abortion tonight. In preparation for this segment, Trace asked a healthcare lobbyist to help us understand the current state of state laws. There are several state laws in effect now. He was told some healthcare lawyers don't want to put anything into writing because of potential legal challenges. The question: what is your interpretation of the current Oklahoma laws regarding abortion, and what decisions do you foresee a district attorney having to make?
Well, I think the Attorney General of the state of Oklahoma has issued an opinion about the new law, and I assume it's not a formal AG opinion, but it is something that he has given to law enforcement and district attorneys to follow. So that will, I mean, that's the guidance, at least from the Attorney General. I mean, if I can address just briefly the laws that we've passed here in Oklahoma, I believe it is pure and simple overreach by the government to issue those laws. I've been talking to doctors throughout Oklahoma County, and they are concerned that their medical judgment has been usurped by the state government. I heard a story from an OBGYN who was telling me that a woman, her patient came to her at 21 weeks and her water broke. She was not permitted to terminate that pregnancy because the fetus had a heartbeat but was not viable outside the mother. She had to wait until the mother developed an infection before she could terminate the pregnancy. I believe, as I said, that these laws well overreach in making medical judgments by physicians.
Mr. Calvey, 90 seconds, same question.
Okay, so I'm Catholic, I'm pro-life, and I do not intend this DA to have to prosecute abortions, and here's why. So last spring, the abortion industry in Oklahoma mostly shut down, with some exceptions, as a result of abortion laws passed by the legislature that provide for enforcement by civil lawsuits from private parties. The DA's office is prohibited from involving themselves in those lawsuits. Here's what the practical result of these laws is. Women can still obtain a legal abortion for any reason about 2 hours away in Wichita, Kansas. Abortion is thus less convenient than before, but hardly impossible. I doubt an Oklahoma doctor is going to risk a civil lawsuit, losing their license, etc., to do an abortion illegally when there is a legal alternative not far away. So will I prosecute a woman for seeking or obtaining an abortion? No. Will I prosecute a woman for traveling to another state to obtain an abortion, or someone who assists her in doing so? No. What an Oklahoman does in another state is up to that state's laws, not Oklahoma's laws. I have many supporters for my DA campaign who know I'm pro-life, but they also support abortion rights. They recognize I'm very practical in my approach. Abortion just really won't be an issue at the DA's office. I will continue my lifelong advocacy for more resources for pregnant women in need. I have long donated my money and my volunteer services as a lawyer to pregnancy resources and the women they serve. And in the legislature, I've championed for more state resources for pregnant women also. And that is what I will continue to do.
Mr. Calvey, I do just want to be clear on this one question. Correct me if I'm wrong, I understood you said you would not prosecute someone who aids another person in receiving an abortion. Is that correct?
Aids somebody in traveling to another state to obtain an abortion.
What if
Correct.
somebody performs an abortion here, though?
If somebody who's not a doctor performs an abortion here or administers abortion drugs, oh yes, we should want to prosecute anybody who tries to usurp the role of a doctor, whether it involves abortion or not.
Well, let's
administering
assume
drugs,
it's a
et
doctor.
cetera.
Let's assume it's a medical doctor.
I'll be honest with you, I just don't think that's likely to happen because they're already risking civil lawsuit and things like that. So I would be inclined to not intend to do so.
But you might.
I would not say never. There's all kinds of factors that could be involved, but it would be my intent not to.
Mrs. Behenna, just, or Storm, I guess this is your question. Don't let me
Yeah.
get in the way.
Do you have any?
Well, I mean, I'm glad to hear that Mr. Calvey says that he's not going to prosecute any women that seek an abortion. I think that's the right answer, and Oklahoma law doesn't provide for a DA. Even the AG has said that women who seek an abortion are not going to be prosecuted under these new laws. But it's much more clouded than that when you're talking about OBGYNs who are caring for women who are pregnant, who have issues with regard to their pregnancy, and whether or not those people would be prosecuted. Again, I think it is government overreach. I think that we have stepped into an arena. We, the government, the state legislature, and the governor of the state have stepped into an area where they should not be.
And so, just to be clear, would you prosecute a woman who sought an abortion here in Oklahoma where it would not be legal, or in Kansas?
No.
Would you prosecute a doctor who performed an abortion in Oklahoma?
I agree. I don't think any doctors are performing abortions here in Oklahoma, so I don't think that's an issue.
If they did?
I mean, I really, we're talking hypotheticals. I would want to know the facts and circumstances surrounding that abortion. Is he just setting up a shop down the street? Or is he terminating a pregnancy because that child or that fetus is not viable? All those facts matter in making those decisions.
Thank you very much. Storm, I think we're going to have Janae Williams join us on stage here. Give Storm a round of applause. And give Ms. Williams a round of applause. Janae, thank you so much for being here. Thank you for the Oklahoman for being a partner on this. This is our first time partner on one of these. I hope it continues. Janae covers Oklahoma County, and she has a pair of questions regarding the long-beleaguered county jail. Janae?
Thank you, Trace. Ms. Behenna, a recent report from Forward.us found that people detained on felony charges in Tulsa County are released on personal recognizance bonds at a rate 5 times that of those detained on similar charges in Oklahoma County. What would your role be as district attorney in closing the gap, and are there any specific changes to bail and bond that would better serve the public?
Yes. Yes, there are. I believe the Oklahoma County Jail is full of people who cannot afford to bond out. That needs to change. So with regard to individuals who have been charged with low-level offenses that are nonviolent, who don't have a history of violence in the community, they're not a danger, and who do not have failures to appear, those individuals should be allowed to an OR bond or personal recognizance bond, clearly. With regard to individuals who are a danger to the community and or flight risk, have other previous failures to appear, that's a different matrix. So the district attorney's office and the public defender's office does have a bond schedule. That bond schedule has not been reviewed in years. I've talked to the public defender about revising that bond schedule to give more transparency on the bond amounts for the particular offenses, but for certain people, we need to make sure that we individualize that bond. In other words, if the person is not a danger and not a flight risk and does not have failures to appear, then they should be allowed a reduced bond amount so they can continue to work and support their families.
Mr. Calvey, same question to you.
Any reforms we do with our criminal justice system must prioritize public safety. We will not have soft-on-crime policies like the Democrat DAs in places like Los Angeles. We do need to keep jail and prison for public safety, not a debtor's prison. There are too many people in jail over fines and fees. I don't think the jail is full of them. I think most of the people in the jail at this point, after some years of some reforms in this area, are people that do need to be in jail. But there still are some. That is correct. Let me give you a case in point. Fines and fees. For people that are facing a conviction and they're ordered to pay fines and fees, especially the $991 DA supervision fee, A lot of times they're required to go back to court every so often. If they miss even one time out of 12, a warrant is issued for failure to appear. That would be one where I don't think somebody ought to go to jail for that. That would be one even on an FTA. Depends on what the FTA is, failure to appear, on whether or not they should go there. We're actually spending more to jail some of these people than we're collecting in the fines and fees. That's not fiscally conservative or humane. I'm also told 20% of the people going to prison are for revocation of a sentence on some sort of technical violation, sometimes because they can't pay for some program in order to complete. The very first goal is to lobby the legislature for full funding up front of the DAs, judges, and public defenders. That will take away any incentive to prosecute for profit. And again, our legislature is overwhelmingly Republican. I'll be effective in talking to him. My opponent won't.
Let me ask a quick follow-up real quick. Commissioner, are you sort of implied that Democrat DAs around the state or around the country, are you implying that Ms. Behenna is going to be dramatically different than you on this topic? Is there somewhere where you guys are different?
On this particular topic, I don't know.
Okay. Ms. Behenna, are you going to be different than Commissioner Calvey on this topic?
On cash bonds?
On cash bonds, on the amount of OR
but
used?
it's a nice label he can place on me, right? I mean, that's what it's about. He can't attack my experience, so he's got to try to place a label on me.
Mr. Calvey, you say you want to improve a corrupt DA's office, but many people say the Oklahoma County Jail and its administration are corrupt, or at best inept. You've been a member of the jail's governing body, the Jail Trust, since its inception, but we typically have not seen you ask tough questions of Jail Administrator Greg Williams during Jail Trust meetings. So tell us specifically, what actions have you taken to address the increase in jail deaths, sexual assaults, and other troubling events?
So first of all, I ask my tough questions not up on the horseshoe, but one-on-one with Mr. Williams and his staff. So my goal as a county commissioner was to get a new jail without a tax increase. Thanks to the voters, that will now be a reality, and that's going to solve a lot of the problems. None of that would have happened without the jail trust. The last time a jail vote occurred on whether to fund a new jail, it only got 15% support and 85% against. People did not trust the former operators of the jail. They were taking money intended to fix the jail and spending it elsewhere. The jail trust is more transparent. That's why you still see news about it. It is the former sheriffs got the Black Hole Award from Freedom of Information Oklahoma for not releasing that. There's over 80,000 pages of records of violence in the jail that were never released to the public. So violence is way, way down in the jail from what it was. It is not perfect, but they're making progress. You can't solve 30 years of mismanagement in just a short time.
Hey, hold on, just be respectful of our moderators here. Let's have this discussion. Janae.
Ms. Behenna,
Well, I would like everybody to stop. Listen. Just one question. I will have Deputy Bellinger remove folks if we have disruptions, so I'm doing my best up here to be fair. I think they both think we're doing a good job, so Janae, let's go back to you.
Ms. Behenna, do you support the Jail Trust's continued operation of the Oklahoma County Jail, or do you believe control would better be placed in the sheriff's office? Why or why not?
Yeah, well, I was at an FOP meeting with many deputy sheriffs, and I can tell you they don't want the jail back. It is a mess, right? I mean, I am not involved in the jail trust. I've not gone to any meetings involving the jail trust. Something has to change with regard to the operation there at the jail. I know Mr. Calvey wants to blame his predecessor and the people that came before him, but quite honestly, more people have died this year alone in the Oklahoma County Jail, and there has been more contraband introduced in the jail just in the past year. I will, as the district attorney, get involved in understanding what's lacking in the jail trust and the operation and make sure that safety of the inmates there, most of these are pretrial detainees. These are not people that have been convicted of any crimes. These are people that we presume to be innocent until proven guilty. They should not be dying in the Oklahoma County Jail.
I want to talk about this a little bit more, Mr. Calvey, 30 seconds
That's one
to you.
thing to say.
Yeah.
So, first of all, the reason most of the people who die in the jail do is because they're about on death's door when they're brought to the jail. It used to be that the DA's office would approve more medical OR bonds. The jail staff tries to get people medically OR'd out, and now, because the current DA does not like the jail trust, he is denying those. That is a big part of the problem.
Well, there's other issues that have happened, right? We've had at least one publicly reported, and I believe a second recent potential sexual assault involving people who were being booked into the facility. We had the hostage situation earlier this year. We've had numerous deaths. There's a civil lawsuit regarding a man who was nearly beaten to death and who, after he got out of the hospital, was put back in the cell with the individual who nearly beat him to death. I would like to know what questions you ask Mr. Williams in private.
First of all, the problem in really any jail, and our jail is no exception to it, is staffing. Staffing is a problem for businesses all over the country. It is not unique to the jail and corrections industry. Our jail is not alone in having these kinds of problems. The more that you are able to get staffing up, and I've been a champion for increasing the pay of jail guards to make sure that that happens. I will tell you, statistically, the violence in the jail is way, way down, especially staff on inmate violence, but also inmate on inmate violence than for what it used to be.
Mrs. Behenna, 30 seconds if you want it. Does the DA need to do something? Mr. Prater would argue that there needs to be some more accountability. He asked for a grand jury investigation that's being handled by Mr. Thorpe out of Cherokee County. What are your thoughts as you watch on?
Look, I mean, it is a crime for somebody to bring contraband into a detention facility. Those things need to be investigated and prosecuted. It is a crime to allow sexual assaults and rapes to occur in the general intake area. Somebody is not supervising properly. There's no excuse for that kind of behavior in a facility that's a detention facility that is run by alleged detention officials who are watching and ensuring safety of the inmates that are there.
Wonderful, thank you. We've reached the end of round, what is it, 2? Give Janae a round of applause. Thank you so much, Janae. Storme, she's coming for your job. We're going to go to round 3, courtroom etiquette, and I appreciate you all being passionate about these issues. That's why we're asking so many follow-up questions, but we appreciate you letting the folks at home still be able to listen without too many outbursts. Janae, great job. Storme, we're going to go to our 3rd round, and I guess I have the first question.
Let's
I thought
do it.
You did. Oh, okay. This is where we ask candidates about their records, their backgrounds, and statements. Mr. Calvey, first question to you. You announced your campaign with a blanket promise to drop criminal charges against the Oklahoma City police officers who fatally shot 15-year-old Stevian Rodriguez after he attempted to commit an armed robbery. You've called those charges, quote, malicious, and have said you would dismiss them on day 1 in office without reviewing the witness statements, officer statements, or other evidence of the shooting that would be available to you once you became district attorney. How do you respond to people who say it's irresponsible to announce a case decision without first reviewing all documents, videos, and interview transcripts?
Here's what's irresponsible. When you file a criminal charge against somebody, you should know that you can prove that charge beyond reasonable doubt. Here's what we do know about that case. The Oklahoma City Police Department did investigate it and found that the shooting was justified. And number 2, the video from the case clearly shows that the armed robber, the violent felon whom they encountered there, disobeyed orders to keep his hands up and reached behind him as if he was going for a weapon. I will support our police, not persecute them. Our current Democrat DA is wrongfully prosecuting these officers. Wrongful prosecutions of police officers demoralize the police, they harm recruitment and retention of police officers, and make them less likely to put themselves in harm's way. And that makes all of us less safe. My opponent has attacked me for standing up to these police officers. That's because she plans to prosecute those officers to cater to anti-police sentiments in her own party, like the Democrat city council members who voted to defund the police. I will dismiss the charges against those officers. I'll look at the file, but unless it says, hey, whoopee, we get to go kill somebody today, I'm still going to dismiss the charges. There's no way you could prove felony charges against those officers at all, much less by reasonable doubt. The responsible thing to do would be never to have filed those charges to begin with and to dismiss those now. It's a matter of standing up for not only those who protect and serve us, but creating public safety. When you undermine the police with wrongful prosecutions, you end up making all of us less safe. When that doesn't mean I wouldn't file charge against an officer ever. It's a different matter when police harm somebody in custody or an innocent person, things like that. But when faced with a known threat, when they only have seconds to react, we shouldn't be prosecuting officers for just doing their job. I will support our police, not persecute them.
Thank you. Mrs. Behenna, 90 seconds, similar question to you. What's your reaction to Mr. Calvey's decision or statement that he would drop those charges right off the bat? And what are your thoughts on the Stevian Rodriguez case and the Benny Edwards shooting?
Well, I think, quite honestly, Mr. Calvey's statements are pandering to law enforcement in order to get their vote. Nobody in their right mind who has ever prosecuted a case would look at a video on TV and decide that those charges were not proper. That's what makes him so dangerous as a district attorney. There is all sorts of evidence involved in this case. I don't know what it is. I've not seen it, but I understand body cam footage taken from different views might substantiate that it was an unreasonable use of force. It is absolutely improper to pander to a group of people to get elected, because I guarantee you the minute after, if he were to win this seat, he would be filing charges against police officers, because if police officers act outside their training and experience, those cases need to be reviewed. Those cases need to be brought. My husband is a career law enforcement officer. I understand fully the difficulty that cops have on the street. I am not saying that I would charge every police officer. I'm going to tell you exactly what I told the FOP. It is improper for anybody to prejudge a case without knowing the facts, because in prosecutions, facts matter.
Mr. Calvey, I'm going to give you 30 seconds to respond to that. It does strike me that when I asked you about the O'Donnell investigation and Speaker McCall's endorsement and those sorts of things, that you said, well, you didn't know the facts and you wanted to wait and review the matter. And in this instance, you say that you have enough information to make that decision. So
we do. There's two things. Number one, the Oklahoma City Police Department did review the case and found that the shooting was justified. And then there's video which clearly shows that the guy who was a known violent felon provoked the officers, and they acted in self-defense and defense of the prosecutors. What's really terrible is for you to pander to these anti-police people like the Democrat city council people that voted to defund the police in your own party. That's what's a problem. And you have to know you're going to be able to prosecute that case and win it beyond reasonable doubt. And there's no way, none, that case could be proven beyond reasonable doubt. So therefore, it should be dismissed.
May I respond?
Yes, ma'am.
First of all, Mr. Calvey, if you were a prosecutor, you would know that the standard to bring a case is not beyond a reasonable doubt. It's preponderance of the evidence. That's the standard. And why would I defund the police when my husband was career law enforcement? He made a career working at taxpayer expense. I hate to say it like that, Scott, but he was funded by taxpayers to do a job, and he did an honorable job, as did all the other police officers and agents that worked with him.
So quit prosecuting them for just defending themselves against known violent felons.
Okay, we've reached the end of that exchange. Storme, I believe you have the next question.
All right, this question will be asked to Ms. Behenna, and Mr. Calvey, you'll have an opportunity to add your comments. Ms. Behenna, your son was charged and convicted for a homicide while serving in the military, and you advocated for him to be pardoned, which President Donald Trump did do in 2019. Currently, as we've mentioned this evening, 7 law enforcement officers are facing felony charges for citizen deaths here in Oklahoma County. Question, is it possible those scenarios could make you think about your son's case? And how would you convince voters that you would not be biased in considering cases of law enforcement caused deaths?
I am a career prosecutor who understands the criminal legal system needs to have a prosecutor who understands that you follow the evidence first and make charging decisions based upon that evidence. Do I feel empathy for people that enter the criminal legal system? Yes, I do. Do I feel empathy for victims that didn't want to be in the criminal legal system, but somebody had violated them or committed violent acts against them that make them enter the system? For 25 years, I reviewed facts to make charging decisions. Police shootings involve not just the facts of the case, but we're now talking about technical issues about whether or not excessive force was used. I have hired and retained experts before to help me evaluate the facts. If a use of force expert in a police case says to me, this is reasonable force, Vicki, and we should not prosecute it, those cases would not be prosecuted. If a use of force expert tells me that the use of force was unreasonable for those facts, then that is a case that I would bring and would prosecute as a DA.
A military prosecutor did go through those questions, and your son was convicted and pardoned. Do you think that that would affect your judgment in making such charging decisions?
No, because I follow the facts.
Mr. Calvey?
Well, I would say, first of all, I'm glad that her son was pardoned. I understand the stresses of being in a combat zone, and people sometimes do things they otherwise would not do when over there. So I'm glad that he was pardoned. But it is awfully hypocritical to go and beg for mercy for your son and then not have any mercy for police officers who are under a much more constrained time frame. And when they were responding to a direct, known violent felon who was threatening them, we should take these things into account. It's almost like a combat situation, I think, for an officer when they're in that situation under threat, and they should be given leeway on that, and they should not be prosecuted for simply doing their job when they're under threat from a known violent felon.
Ms. Behenna?
It is irresponsible to make that statement without reviewing facts. That makes you so dangerous as a district
I want to say one other
attorney.
thing. You said a minute ago something very shocking. You said the standard for convicting somebody on a felony charge is preponderance of the evidence.
No,
Oh, no.
no, you
That's the
misunderstand.
standard for a civil case. The standard to
no.
prosecute and convict a person
It's-
on a case in which there's a felony charge is beyond reasonable doubt. If you don't think you can finish that case and convict them beyond reasonable doubt, you shouldn't be filing the charge.
I'm talking about bringing, may I?
Please,
I'm
let's
talking
hear what they
about
say.
charging decisions. I'm not talking about conviction. Of course, that's reasonable doubt. But the decision that a prosecutor makes is not looking at whether or not I'm going to be able to prove it beyond a reasonable doubt. They determine whether they have sufficient evidence to bind somebody over and to prove that that person committed the crime. The jury makes a decision on whether or not the proof was beyond a reasonable doubt.
You shouldn't be running cops through the ringer based on anything less than you think you're going to win that case on a reasonable doubt. It is undermining public safety when you do so.
All righty.
Ms. Behenna, final 15 seconds if you want it. We good? Okay.
This
Storme.
question will begin with Mr. Calvey, and we'll do the same kind of exchange. Mr. Calvey, you called an August press conference in front of David Prater's office to allege that he improperly and politically asked the OSBI to investigate concerns about a contractor your office used for official county work, who's also employed by you for campaign work. The question: have you been contacted by the OSBI, and if you were in Prater's position where allegations were made against someone running to succeed in his office, would you not have acted similarly by referring the matter to another agency?
So this was nothing but a political hack job by David Prater, which he's done to so many people so many times. I've been very critical of the current DA, David Prater. He unethically requested this investigation of me. What he should have done is simply said to people that were saying anything about me, go talk to the Attorney General's office, and then the Attorney General would decide whether to farm it out, ask for an investigation, etc. Instead, he did it and then managed to get that leaked to the press right before my runoff election, which so happened to be against one of David Prater's cronies. My opponent has said that anybody in investigation should not be the DA. That's a shocking violation of due process. She said that in the news right after the runoff. God help us if she becomes DA with that lack of respect for the presumption of innocence. Maybe she'll change her tune when other things start getting investigated. The OSBI tells me they are done with their investigation. They did talk to me. It's clear that they realize the allegations are false. This was nothing but a political hatchet job by David Prater.
Ms. Behenna, 90 seconds.
Will you repeat the question again? He kind of.
Yeah, the question was, if allegations were to be made against someone running to succeed you in office, would you have not acted similarly by referring this matter to another agency? Mr. Calvey has obviously defended himself and said this investigation is a political witch hunt.
Right.
Do you support his summary of the facts?
Well, I don't know the facts, and I don't know why he called a press conference to announce the investigation. But if there is an issue regarding, again, the appearance of impropriety, whether or not it involved, if I had been David Prater and there was an investigation about an opponent and when Galen Gigger was in a runoff with them, I definitely would have referred that to somebody else. Again, we need to have people have confidence in the criminal legal system, that investigations are being done for a proper purpose and not for a political gain or personal gain. And so, yes, I would have referred that investigation outside of the office as well.
What about the statement that Mr. Calvey raised? You were quoted saying that someone under investigation should not be elected to public office. Do you support that notion?
Well, I don't remember saying that.
You were
but
quoted in the
gosh,
paper.
I mean, if you're under investigation by the OSBI, it questions to me whether or not you can properly make charging decisions that need to be made in the DA's office.
Well, that's a shocking violation of due process. Anybody can call for an investigation. You don't even have to have any proof. You don't have to have probable cause or anything to call for an investigation. God help us if anybody, you can just say, you're under investigation, you're under investigation, you're under investigation, and then all of a sudden, you're going to jail or you're not eligible for some, public office or, some appointment or something like that. Investigations are merely that, and that statement was very reckless of you and not at all consistent with the constitutional rights that are protected for all of us Americans.
I have one quick question, Mr. Calvey. You said that you again alleged that Mr. Prater alerted the media, in specific Nolan Clay of the Oklahoman was the one who was calling you about it. Mr. Clay has said that he was not contacted about it by Mr. Prater.
Not directly.
So you believe it was still...
Yes, it was
Mr.
certainly
Clay
engineered by David Prater. It's his MO. He's done it for years and years.
Okay, appreciate your time. Ms. Behenna, I have the final round of this question. Final question of this round. You and your other son, Brett, represent Bobby Chris Mays, the former owner of Big Red Sports and Imports and other car dealerships.
Yes.
Mr. Mays and a woman named Courtney Wells and a third co-defendant were convicted of wire fraud, conspiracy, forgery, identity theft by a federal jury. I'm not making this up. While the case awaits sentencing, you filed a motion seeking a new trial on purportedly new and exculpatory evidence, a folder of printed emails that indicate Ms. Wells apparently led the scheme without Mr. Mays' knowledge. Prosecutors don't necessarily believe that's the case, but subsequently Ms. Wells and her new husband have disappeared, abandoning their teenage daughter. In responding to your motion, those prosecutors say that the series of emails cannot be authenticated and, quote, simply do not look anything like actual previously authenticated emails from Ms. Wells. Prosecutors also wrote that the, quote, only person who benefits from Ms. Wells' inexplicable disappearance is Mr. Mays. Question is, if you truly believe these emails that you filed are authentic, how did you and your co-counsel not discover this exculpatory evidence for the past 2 years? And what do you think happened to Ms. Wells?
Yeah, I'm happy to answer those questions, at least as far as the evidence is in public documents, okay?
Sure.
So if you had read all the documents in the case and all the filings, you would know that the case, we went to trial last November. There were allegations of prosecutorial misconduct in the case. As a matter of fact, we had to file 2 motions for a mistrial as a result of prosecutorial misconduct. Many motions have been filed in that case, including motions for sufficiency of the evidence as a result of sufficiency of the evidence, I can't even talk now, and prosecutorial misconduct. I don't know where Ms. Wells is, but I venture to say that she left because she told many of her cohorts that she was going to leave as a result of her sentencing. She said that she would not serve a day in court. As a matter of fact, I think before she left, we are now discovering that she was assigning her property, her home, and other assets that she had to her daughter well in advance of when she left. If you're trying to insinuate that somehow I was involved in doing some things to assist my client, I will tell you this. I would not have survived 30 years in this legal community and have the reputation that I have with judges and my fellow lawyers without first verifying and authenticating evidence presented to a court. You would know, if you had read the public filings, that there was a document expert, a document examiner that reviewed those emails, validated and verified those emails before they were presented to a court. And I can tell you, if an Article III judge thought anything inappropriate was happening, I would have heard about it from the judge.
Prosecutors argue, I did read the documents. The prosecutors argued that he was not an expert that was qualified to make that determination. Before we get to Mr. Calvey's response, what was the allegation of prosecutorial misconduct? Since we are running for a prosecutorial position, I was curious.
Sure. The prosecutorial misconduct was improper questions that were asked on cross-examination in which the prosecutor had no reasonable basis in fact to ask those questions. So it's an ethical issue with regard to prosecutors. They can't ask questions that they don't believe there's any truth to it. The judge admonished the prosecutor and referred her for investigation by the Office of Inspector General at DOJ. There is now yet, if you would know that, we filed a motion last Thursday for yet another continuance of a hearing because information that has recently become available, again insinuating that the prosecutors withheld over 300 text messages from the defense that they had in their possession, but before the case went to trial. That's another allegation of prosecutorial misconduct. That would be a Giglio violation of which the prosecutor should have turned that evidence over so that we could have used it for cross-examination.
Thank you very much. Mr. Calvey, 90 seconds, your reaction to this situation.
Well, first of all, kudos to Sylvia Corkill at News 9 for breaking the story last night. 2 Oklahomans are missing and may have been murdered because Vicki Behenna was willing to submit fake documents to a federal court to get her crooked client out of prison. These are the facts, according to the U.S. Attorney's Office. Her client, Chris Mays, was convicted last year. May 2nd, Courtney Wells, also a co-defendant and an employee of Chris Mays, and her husband have been missing. That was, by the way, a few days before her only daughter's high school graduation. Who goes on the lam at such a time? Nobody. A few days after that, Ms. Behenna filed a motion for new trial for Mays, based on what the U.S. Attorney's Office says and has abundant proof of are fake documents that Behenna submitted to the court. These fake documents could only be corroborated by Wells, who was conveniently missing. As the U.S. Attorney's Office said, Ms. Wells had no incentive to go missing, and the only person who benefits from her disappearance is Mays, Behenna's client. The U.S. Attorney's Office implies that Mays caused Wells' disappearance. And yes, that document expert is a schlock, as the U.S. Attorney's Office points out. It's very hard to stay missing for 5 months, so sadly, it seems unfortunately likely that Ms. Wells and her husband are dead. For the sake of the safety of other witnesses in the case, Chris Mays should be taken into custody or at least made to wear a titanium ankle monitor right now. The question Oklahomans are increasingly going to ask is, where is Courtney Wells? My opponent's actions in this case are a stain on her record. Even in the unlikely event that Ms. Behenna were elected DA, she'd have to be removed from office soon thereafter because of this ethical stain.
Ms. Behenna, let's have you respond.
Yeah, you know, it doesn't surprise me that Mr. Calvey would make these statements. He is a career politician who has created a false narrative for his own political gain. This is something politicians do. This is not something a district attorney does, because you cannot pick and choose facts that you want to listen to, Mr. Calvey. Why don't you review all the pleadings in the case and find out what all the evidence is, and before you start creating false narratives for your own political gain?
I didn't create the narrative. I'm just quoting the U.S. Attorney's Office in this case. It is very dangerous. And this case is a stain on your career, and you would be removed from office if you happen to get elected.
I can't hear what was said, so I don't know, but maybe, hopefully the journalists can. We can go back to the tape. Any final thoughts, Ms. Behenna, Ms. Calvey, on that matter? It looks like a maybe.
Well, I'm trying to think about how to say this. I mean, it is shocking to me that Mr. Calvey would issue a press release. I mean, he tried to peddle this story to 2 other news sources who didn't pick it up, because what he was peddling, again, was a false narrative based upon bits and pieces of what he considers to be facts. He is a dangerous person for a district attorney's office. If he will do this to win an election, what is he going to do in the district attorney's office when it is important for the district attorney to have the integrity and be above reproach and not create false narratives for your own benefit?
Mr. Calvey, 15 seconds, finish this
Again,
out.
it's
Real
the
quick,
it's what the U.S. Attorney said, and what's shocking and dangerous is that you would submit fake evidence, fake documents to a court, and that as a result of that, your complicity in that, 2 Oklahomans are missing and probably murdered. That's shocking, and that is shocking.
May I respond?
Yes, ma'am, yes.
He has no idea what he's talking about. He has no idea.
Read the
what
U.S.
he's
Attorney's
talking
document.
Okay, Storme, I think we've reached the end of round 3. I appreciate your time. And if anybody's worried, these people are running to be a prosecutor, like they handle this stuff in court all the time. So we're going to have closing statements, 90 seconds each. Mrs. Behenna, you are going to go first, followed by Mr. Calvey. 90 seconds to you to close out.
Thank you. And again, thank you for hosting this debate for us. I was born in Oklahoma County, and I've lived here most of my life. I care about this place. I care about public safety. I care about the criminal legal system. I care about people who are hurt and traumatized by violence. I've spent my entire career in the criminal legal system, and I would not have the reputation I have if I wasn't a person with integrity and fairness. I was a prosecutor here for 25 years, a defense lawyer, the director of the Oklahoma Innocence Project to help right wrongful convictions. My husband was career law enforcement. My opponent, on the other hand, is a career politician and lobbyist, and the only one up here on this stage that's been under investigation by the OSBI. If I take him at his word that he tried all of these cases while he was in the military for 1 year, which happened 14 years ago, with no other criminal trials since that time, he is still a rookie ADA. My opponent has never reviewed investigative files. He's never talked to investigators. He's never talked to witnesses. He's never had to sit with victims. He's never made charging decisions. He has never made the weighty sentencing decisions that a prosecutor has to make. I have done that for 25 years. I have not only made those decisions, but I have tried numerous cases. I have moved through the criminal legal system not to pad my resume for political gain, but because my heart moved me to these new challenges to try to make things better. My name is Vicki Behenna. I respectfully ask for your vote for District Attorney on November 8th.
Thank you very much. Mr. Calvey, we'll give you an extra 15 seconds or so, but up to 2 minutes for your closing. We should went a little over.
Very good. My integrity speaks for itself, and as far as my record prosecuting, I would refer you to the Bronze Star Medal citation that the Army awarded me. They certainly would not have awarded that to me if I did not have integrity, and that describes in some detail the prosecutions I did over there. I have represented victims on VPOs and other things, and I do know that that's very important. I'm running for DA to put the focus of the office on public safety and helping victims of crime. My opponent said she's for fairness. I agree with fairness, but the focus has to be public safety. That is number one. Again, we can't afford to let Oklahoma County go the way of other urban areas led by Democrat DAs. I do have a lot of Democrat support. They know I'm going to change the DA's office, make it more fair to all the stakeholders in the system, including law enforcement, defense counsel, judges, everybody else. I did prosecute terrorists for the Army in a combat zone, and I'm sorry that she disparages the experience of veterans in saying I don't have experience doing prosecutions. Again, the DA in an urban county is an administrator who rarely prosecutes a case personally. You need somebody who is going to hit the ground running, working with all the stakeholders in the system. That's something I already am plugged into, and she is not. And most importantly, you need somebody as DA who is going to be able to go and make changes at the legislature to fully fund the DAs and all that, so we don't have any incentive to prosecute for profit and seek changes in the system that are going to policies that will lead that. As a Democrat, she won't get the first base out there. I will. I know how to do that. For the administration that this job is, and it's an administrative job, I am far more qualified than my opponent. And even if she does manage to get elected, I don't think it'll last long. Thank you.
Thank you very much. That, as I get to the end of it, that concludes our debate tonight. Thank you to the candidates for participating in this. It's not an easy task. I appreciate you both for doing this. It means a lot. You lead the way for other candidates. Thank you to News 9. Thank you to the Oklahoman, the Frontier, all our friends in the media who have shared and covered this debate. Remember, Election Day is November 8th. We have a gubernatorial debate between Kevin Stitt and Joy Hoffmeister on October 19th. Thank you all and good night. Hit that music, Parker.
Thank you so much.